And joining us now, he's an election lawyer. He served on the voting rights section of the U.S. Department of Justice. His New York Times best-selling book called Injustice, Exposing the Racial Agenda of the Obama Justice Department. And he also has a website, electionlawcenter.com. You'll remember J. Christian Adams, of course, as the leading whistleblower in the new Black Panthers case coming out of Philadelphia. And he joins us now to talk about yesterday's Supreme Court ruling on the Voting Rights Act of 1965. Hi, J. Christian Adams.
Good morning, guys.
So what does this mean to the states?
Well, it means that the states don't have to come hat in hand to Eric Holder and the Justice Department anytime they want to move a polling place 20 feet or enact any election law change in their state. It restores the constitutional order where the states are in charge of their own elections.
All right, but now I've heard a lot of different takes on this, and certainly the takes from liberals, they were through the roof. I mean, you saw MSNBC commentator there, Melissa Harris Perry, said that she felt like she had lost her citizenship yesterday, and everybody was upset and saddened. But there other analysis says, listen, this is just one part of this. It was just Section 5, and it really only throws out a section here about how Congress or how the Department of Justice determines which states have to answer to this, and Congress can actually change the law and make a modification, and it goes right back to where it was.
Well, the problem with that analysis is, though, that the Supreme Court left Congress almost no room to do that. It effectively buried Section 5 forever because it essentially said, the court said, that the circumstances must resemble something approximately 1964-65-ish. It says extraordinary circumstances. Extraordinary circumstances is how the Supreme Court in 1966 described the South, and you just aren't going to find those sort of circumstances anymore. So congressional Republicans can move on to other issues because the court left virtually no room to do anything about this.
Well, playing devil's advocate, those on the other side would say, well, look, that's the reason that it is better now, is because these laws were in place, and there was a system set up where the states were monitored by the federal government.
Well, that's the court dealt with that argument and said that doesn't justify perpetual receivership. But more importantly, Brian, they have other laws in the Voting Rights Act, namely Section 2, that are going to continue to allow plaintiffs to bring cases to stop racial discrimination countrywide. So this is one of the dishonest things that the left will be saying over the next couple of months, is that the Voting Rights Act has been gutted. It hasn't. Go bring Section 2 cases if you're interested in fighting some of these laws.
Now, Chief Justice John Roberts has said you can't basically just say that things have never changed. You have to take some sort of recognition of the fact that things are better in the South than they were back in 1965. And he points to some statistics that are out there that suggest that, in fact, black registration rates were higher than whites in some areas.
Like Mississippi.
Yeah.
Mississippi has more elected officials per capita that are African American than are white. I mean, if that doesn't show a change, nothing does. But look, the founders wanted power to be diffused because they knew it protected individual liberty. When you have 50 states running their own elections, there's more freedom. And that's exactly what the Supreme Court said yesterday, that under the 10th Amendment, there's a term you don't hear very often, under the 10th Amendment, diffusion of power among the states makes us all more free.
All right, so J. Christian Adams is our guest, and we're talking about yesterday's ruling from the Supreme Court on the Voting Rights Act of 1965. Here's what I'm challenged about this, because I don't like it when the court legislates, be it on the conservative side of the ledger or the liberal side of the ledger. And it seems to me this, unless I'm understanding it wrong, they're basically saying, now that we're in 2013, this law is no longer needed, therefore we're striking it down. Well, shouldn't that be for elected representatives to determine? I mean, if it is unconstitutional today, that means it was unconstitutional back in 1965 as well.
No, that's not correct. Because of a concept called congruence and proportionality. That is a concept that says the law must fit the needs. I've read somebody who wrote that, and they were wrong who wrote that. The law could be constitutional in 65, but over time it's no longer congruent to the circumstances. It's no longer proportional to the need. And the Supreme Court has developed this theory as a way to limit federal power. That you simply can't have a law that worked in 65 that is now doesn't work. And the reason
that almost sounds like the Constitution is a living, breathing document.
Except for one thing, Larry. This is a law that was probably the biggest intrusion into state sovereignty that ever existed. And it was appropriate at the time when My Fair Lady was the Best Picture winner. But
you didn't know J. Christian Adams could pull out a musical theater reference there, did you?
That's right. But it was appropriate back then, before the Beatles released Rubber Soul. But now it's totally different.
Okay.
And the 15th Amendment limits the power of Congress. It has to be appropriate legislation. This isn't legislating. This is reading the Constitution itself.
Well, this has some immediate ramifications. I mean, I read that in Texas, where they had a voter ID law that I guess was about to be subjected to federal scrutiny, they said, oh, we'll just go ahead and implement that now. And immediately they started doing that.
Well, Texas isn't the only state. Let me give you the list. Texas, Alabama, Mississippi, Virginia, North Carolina is next. Look, this is a law that has been subject to so much abuse by the Department of Justice. The lawyers there have been sanctioned millions of dollars for abusing this law. There has been perjury associated with enforcement of Section 5, documented by courts and inspectors general. This is a law. One time, the voting section asked Bill Pryor, who is the Alabama Attorney General, to submit for pre-clearance approval a prisoner DNA testing program. That has nothing to do with elections, but it shows you how federal power is subject to abuse when it just sits around and doesn't belong anymore.
Well, and let's delve into that aspect of it real fast, because, again, you worked in the voting rights section of the U.S. Department of Justice. That was the section that really, focused on this specific law, the Voting Rights Act of 1965. How many people in their little cubicles and offices there working with you in the voting rights section at DOJ, how many of them were involved in this minutia, this district in Alabama wants to move the precinct from an elementary school to, this person's garage? That all had to be approved by a bureaucrat in Washington, right?
That's right. And over the course of a year, you're talking about 55 people. Well, yesterday, Tom Perez, the embattled labor secretary nominee who runs this unit of justice, went down to the voting section and had a meeting with the Solicitor Generals there also. And he announced, is anybody going to lose their jobs? And he had a two-version answer, the one word and the two word. He said no and hell no.
Wow.
So Tom Perez is sticking up his nose at the U.S. Supreme Court and simply says nothing's going to change.
All right.
Business as usual.
We got to leave it there. J. Christian Adams, thanks so much for giving us this insight. Again, his New York Times bestselling book is Injustice, Exposing the Racial Agenda of the Obama Justice Department, and you can check him out at his website, electionlawcenter.com.